I'm Seth Guggenheim, Chairman of the Alexandria Bar Association's Lawyer Referral Service Committee. The purpose of this videotape is to assist you in representing yourself before a General District Court in Virginia. Perhaps, after watching this tape, you may decide that you don't feel comfortable representing yourself and that conferring with an attorney about your case would be a good idea. Be mindful that the clerks of the General District Courts are there to assist you by providing forms and giving you information of a procedural nature. However, the clerks are not permitted to give you legal advice. Any legal advice that you need should come from a lawyer. If you don't know a lawyer, a good starting point for seeking assistance would be a lawyer referral service sponsored by a bar association in your area. The clerk of the General District Court nearest you should be able to direct you to the lawyer referral service most convenient to your home or workplace. You may have heard the term small claims court. A small claims court operates with relaxed procedures, especially with regard to the admissibility of evidence, much in the manner that you may have seen on popular television programs. Some jurisdictions in Virginia have recently established small claims court. In most Virginia jurisdictions, however, the General District Court is not a small claims court. This means that even without an attorney, you are required to follow the same rules that lawyers follow. To find out if there is a small claims court that could hear your case, please contact the General District Court Clerk's office. You are about to see a mock trial concerning a landlord-tenant dispute. The action will be stopped from time to time so that you can be given advice of do's and don'ts. After the mock trial, we will introduce you to the basic form that is used to begin a case in the General District Court, and we will discuss with you some important considerations in enforcing a judgment that the court has rendered. Let's watch.
All rise. The Alexandria General District Court is now in session. The Honorable Daniel Fairfax of Flaherty presiding. Please be seated and come to order.
Are the parties ready in the case of Teresa Tennant versus Oswald Owner?
Yes, Your Honor.
Would everyone who would be testifying in this case please stand, raise your right hand, and be sworn? You need to solemnly swear the testimony that you will give in the matter now to be heard will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Will the parties please take your seats at the tables? Do either of you request a rule on the witnesses?
What's that, Your Honor?
Well, the law permits either of you to request that the witnesses be excluded from the courtroom so they may not hear each other's testimony until after they have testified.
Note that not every judge will remind you of your rights respecting the rule on witnesses at the beginning of a case. You should, at that time, ask the judge to apply the rule if you feel it would help your case.
It's okay with me if everyone stays, Your Honor.
Same here, Judge.
Does the plaintiff have an opening statement?
Always stand when addressing the judge and when questioning a witness. This shows respect for the judge and is the proper courtroom procedure.
Thank you, Your Honor. My name is Teresa Tennant, and I am here today because my former landlord, Mr. Owner over there, is guilty of unlawfully, illicitly, and without provocation keeping my security deposit of $675. I feel that he is not entitled to keep the security deposit and that I should get it back because I did not do any damage to the apartment, which wasn't all that nice anyway, if you know what I mean, Your Honor. Anyway, I'm a scrupulously clean person, and I left that place in better condition than when I moved in 3 years ago. I scrubbed the floor and the linoleum floor in the kitchen, vacuumed the old carpets, and polished every surface in the place. In fact, my boyfriend Fred saw the apartment after I finished cleaning it, and he said that we could have eaten off the floors. Also, I always abided by the terms of the lease, and gave Mr. Owner 30 days notice that I was moving out, just like the lease said. Thus, I believe that I should get all of my money back, plus punitive damages, as Mr. Owner is guilty of unlawful retention of my money, breach of contract, bad faith, and malicious persecution.
You have just seen the plaintiff's opening statement. Each party to a lawsuit is entitled to make one. The purpose of the opening statement is to familiarize the judge with the nature of your claim or defense, and to advise the judge of what it is you expect the evidence to show. It is not the time when you present evidence. Do not fall into the trap of testifying instead of telling the court what you expect the evidence to show. You have no obligation to make an opening statement, but it is almost always advisable. You have heard the plaintiff refer to punitive damages and malicious persecution. Be careful not to make casual and inappropriate use of legal or legal-sounding terms with which you are not familiar. You are permitted to refer to your notes during an opening statement, but it is not advisable to read directly from them. You are about to watch the defendant's opening statement.
Mr. Owner, would you like to make an opening statement?
Yes, Judge. Thank you. I'm a law-abiding taxpayer, and I resent Ms. Tennant's inferences that my apartment was anything less than first class. I've sat here to heard about all I can take. I'll tell you how she really treated my apartment, and to prove it, I have pictures. Her creatures chewed the molding in the kitchen and left stains and odors on the bedroom carpet. She left a hole in the bedroom door, cigarette burns on the kitchen counter, and grooves in the kitchen counter.
The defendant landlord did indicate what he expected the evidence to show, but he should have limited his remarks to references to the evidence. It is not proper to make statements of personal feelings about the case or about what the other party has said.
Ms. Tennant, call your first witness, or if you are your own first witness, please take the witness stand.
When you are not represented by an attorney and you are your own witness, you should testify narratively, as if telling a story.
As I said earlier, my name is Teresa Tennant. In May of 1987, I decided to look for a job here in Washington, in the Washington area. So I packed up my VW and drove here. I had no job, no apartment, nothing, but I had always wanted to live in the Washington area. Anyway, I saw an ad for Mr. Owner's place and went on over to look at it. It was not the nicest place, and the price was pretty steep, but I was so confident that I would get a job that I signed a lease and gave him a security deposit of $675. I offer this canceled check as evidence.
Can you show that to Mr. Owner, please, sir? Any objection to this being received in evidence, sir?
No, Your Honor.
Very well, without objection, it's received and marked as plaintiff's exhibit number 1.
Well, I got a job the next month at the Smithsonian Museum of Natural History. They had just opened an interpretive division on the biospheric life cycle of the ferret, and I was hired as a ferret ranger. I know it isn't exactly Capitol Hill, but the fringe benefits have been great. I get first pick of the ferret litter.
You should not stray from a presentation of relevant evidence by discussing any details that are not a part of the case you are presenting. If you do, the judge may interrupt you to get you back on track.
Ms. Tennant, does the life cycle of the ferret have anything to do with this case?
I'm sorry, Your Honor. Anyway, I've always paid my rent on time, even on my meager salary, except for 2 occasions, and he didn't complain then. Besides, I've always been understanding about the less than ideal living conditions that I have had to endure for the last 3 years. I never bothered Mr. Owner about the noisy upstairs neighbors who played music constantly, or the broken dishwasher, or the temperamental garbage disposal, or the disgusting paint that was peeling and flaking off the walls. The place, as it turns out, was definitely not worth $675 a month, but I continued to pay my rent every month because I was getting quite attached to the neighborhood. Besides, unlike some people, I believe in honoring the contracts that I sign.
This last remark was inappropriate. As is the case with opening statements, you should avoid making personal attacks on the other party.
2 months ago, I gave Mr. Owner 30 days notice that I was moving out. On the day I moved out, I spent $12.83 at Murphy's on cleaning supplies and scrubbed and vacuumed and dusted that place until my arms ached. As I said before, when I got through cleaning, the place was so clean, my friend Fred and I could have eaten off the floors. Mr. Owner is being overly finicky about so-called damage. As I said time and time again, the place wasn't in great condition when I moved in. I never punched a hole in the bedroom door. I'm outraged that Mr. Owner would accuse me of such a thing, as I do not have a bad temper. Second, I do not even own a dog, so the molding in the kitchen could not have been chewed even during my occupancy. It was like that when I moved in. As far as the stains and the odors in the bedroom go, I admit that Pookie had a little trouble with her house training, but that was just normal wear and tear that happens to an apartment over the course of 3 years. It goes with the territory of renting. Mr. Owner should not be in this business if he is not willing to take risks with regard to his property. I have a notarized statement from my new landlord that says, pet stains and odors on carpets are normal wear and tear.
Your Honor, I object. my lawyer told me that affidavits and notarized statements couldn't be used at trial.
Objection sustained. Resume your testimony, Ms. Tennant.
Generally, out-of-court statements by anyone other than the plaintiff or defendant are known as hearsay and may not be used at trial. If a party objects, the rules against hearsay evidence apply in most instances to affidavits and notarized statements. It is therefore almost always advisable to bring with you every witness whose testimony you believe will help your case.
In conclusion, my evidence proves that I deserve a full refund of my security deposit, and Mr. Owner should be enjoined from withholding it from me.
Do you wish to cross-examine the witness, sir?
Cross-examination is your opportunity to question the other party's witnesses. It is not a time for you to testify yourself or to make speeches. If you choose to cross-examine a witness, you are required to ask questions. The primary purpose of cross-examination is to pinpoint the weaknesses in the witness's testimony.
Yes, Your Honor. Miss Tennant, did you inspect this apartment before you moved into it?
What do you mean inspect?
You know, look around, see if everything's all right.
I just moved in and started living there.
Isn't it true that you had pets while you were living there?
Well, yes, but she was just a well-mannered ferret.
Isn't it true that your ferret chewed up the molding on the kitchen?
I honestly don't think so. She did get lead poisoning, though, from the ancient paint in the place.
Isn't it also true that your ferret was not house-trained?
Well, not at first, but that's just normal wear and tear. Besides...
Doesn't our lease say that you're not allowed to have pets in the apartment?
Well, yes.
Well, did you read the lease?
Well, sort of.
Sort of. Is that a yes or no?
I guess it's a yes.
When you moved in, you didn't think the apartment was in poor condition, did you?
No, it was nothing compared to Topeka, but I didn't know what to expect here.
You didn't mention a hole in the bedroom door when you moved in, did you?
I really didn't notice. I was so excited about my new job and my new apartment.
You didn't say anything about paint chips when you moved in, did you?
No.
Thank you. Miss Tennant, you didn't pay your rent for the month of October of last year, did you?
Not right away. I was out of town at a funeral. Have a little sympathy. Besides, you didn't complain then.
And also, you didn't pay your rent for the month of August of last year, did you?
I was in Kansas then, and I was going to pay it when I got back, and I did pay it when I got back.
If you didn't pay your rent for the month of August and October on time, and if your ferret chewed up the molding and messed up the carpet, you shouldn't get your money back, should you?
Of course I should, because what little damage little Pookie did was just normal wear and tear.
How many apartments had you visited when you lived in Topeka?
I knew a few friends who lived in apartments, but I never lived in one.
How many apartments have you visited since you moved from Kansas?
Just one or two others.
Miss Tennant, did you read the lease before you signed it?
She's already answered that question, Mr. Owner. Move on, please.
Once a witness has answered a question, you generally may not ask that same question again. This is to avoid wasting the court's time and to prevent badgering of the witness.
What was the condition of the door when you moved in?
Well, it wasn't perfect by any means. There were some scratches and stuff.
Do you have any evidence of that fact?
What do you mean, evidence?
Do you have any photographs?
Well, of course not.
Do you have any friends or neighbors that can testify about the condition of the door when you moved in?
You know I was new in town and didn't meet anyone for a while.
I have no further questions, Your Honor.
Ms. Tennant, do you have any further testimony to offer? If not, please return to your seat at the table and call your next witness.
Thank you, Your Honor. I call Fred Friend as my next witness.
Yes, ma'am.
Please state your name for the record.
My name is Fred Friend. I've been a close friend of Teresa's for a couple of years since we met at the ferret compound at the zoo.
Did you ever see me buy cleaning supplies and then use those cleaning supplies around the time I moved out of Mr. Owner's apartment?
Yes, Your Honor. I took Teresa down to Murphy's and she spent $12.83 on cleaning supplies. And then I saw her scrub the place and vacuum it thoroughly. And I couldn't help her because I have allergies and I'm allergic to dust. So I went out to get some lunch for us, and when I came back, the place was real clean. I mean, we could have We could have literally eaten right off the tabletops, the countertops, the floor, whatever. I think this guy, Mr. Owner, is just crazy. He's just out to get Teresa and trying to get some extra money.
As stated before, personal attacks are inappropriate. Your witnesses should be advised before trial to refrain from expressing personal opinions concerning other parties.
I have no further questions, Your Honor.
Mr. Owner, you may examine.
Thank you, Your Honor. Mr. Friend, how long was it after Miss Tennant moved in before you actually visited her in the apartment?
Well, I don't know exactly. It was within a few months.
It's true, isn't it, that you're not able to tell us what the apartment was like when she moved in?
Well, I mean, I know what it looked like pretty soon after she moved in, because I asked her about it. I asked her how come, you know, she took such a lousy place and how much rent she was paying.
Did she tell you what it looked like when she first decided to live there?
Yeah. Yeah, I mean, she said it was bad when she moved in, but she didn't have a lot of time to look around for a place, and she figured she'd take it as is because she had her pet ferret, and that ferret meant a lot to her. So she figured she'd take the place, and in that kind of shape, the owner wouldn't be so concerned about any damage and wouldn't try to evict her.
Did you see a large hole in the door?
Yeah, I saw the hole. That hole showed up mysteriously one day suddenly when we were out together. We figured it was probably you that did it. You know, you got a pretty bad reputation for doing stuff like that.
Just answer the questions, if you will, please, sir.
Witnesses generally must testify on the basis of what they have observed. Opinions and suspicions are not acceptable testimony, except by expert witnesses. Therefore, when preparing your case, be sure that you select witnesses having personal knowledge of the matters their testimony will concern.
Can you describe the damage that was done by Ms. Tennant's pets?
Look, ferrets are clean and loving animals. They are very rapidly becoming a very popular companion. Teresa and I have been trying to get them licensed and, you know, legalized as house pets. And I don't have anything against ferrets.
What cleaning supplies did she buy for $12.83?
Well, I mean, she got them on sale, and probably by $25 worth of supplies. There was plenty to do the job with. But I told her, I said, I didn't see why she bothered, because he should have cleaned the place up himself, you know, got one of those maid services or something. But I didn't say anything else.
Did she, in fact, clean the apartment?
Yeah, she was exhausted. I mean, she cleaned that place like it was hospital clean. You could have eaten off the floors, you know, that green countertop. She made that thing actually shine. That was a first.
And am I correct in understanding that you were not able to assist her in this cleaning project because of your allergies?
That's right. Like I said, I'm allergic to dust, so I had to resist my natural inclination to help her.
You stated that this cleaning project was carried out while you went out to a carryout and picked up lunch. Exactly how long were you gone?
I don't know, maybe 20 minutes, just around the corner. I picked up a couple of the specials.
I have no further questions, Your Honor.
Ms. Tennant, do you have any further questions on redirect?
No, thank you, Your Honor, and the plaintiff rests.
Always let the judge know when you have completed the presentation of your side of the case. When your last witness finishes testifying, you rest your case.
Mr. Owner, Ms. Tennant has rested her case in chief. You may proceed at this time. You may call your first witness, or if you're your own first witness, you may take the witness stand, sir.
Thank you, Your Honor. Your Honor, I've owned this garden unit since 1967, and I have never had an occupant like Ms. Tennant. She bounced 2 rent checks. She was frequently late with rent. And the way she kept the place, you would have thought her mother would have taught her better. I should have listened to the upstairs neighbors when they complained. They were such nice, lease-abiding people, always playing nice, soft music. Anyway, I had my handyman, Jack, open the door a couple times so we could check the place. And when we went in, she had taken a nice, decent, family kind of place and turned it into a dump. There were beer cans all over the place, dirty dishes piled up in the sink, carry-out pizza boxes on the counter, Her bed wasn't even made up.
I object, Your Honor. That simply isn't true. I never left pizza boxes or beer cans lying around.
Objection overruled, Ms. Tennant. Simply alleging that a statement is untrue is not a proper, acceptable basis for an objection. Please continue, Mr. Owner.
You are not allowed to object to a statement simply because you believe that testimony is not true. You may only object if there is a sufficient basis in the law for certain testimony to be excluded from evidence at trial.
Thank you, Your Honor. There was this scrawny dog there. Looked like a weasel to me. Worthless creature, in my opinion. Anyway, I talked to my lawyer. I wrote to Miss Tennant about the problems. But my lawyer told me I probably couldn't get her evicted. He told me the best thing to do was to take the damage out of her security deposit. And that's what I'm trying to do. So she informed me that she was moving out, and I said that's fine with me. And after she was out, Jack and I went up to check the place out. And like I said before, she'd cleaned the place, but there was some real damage. I made you a list. Hole in the bedroom door, stains and odors in the carpet, chewed up kitchen molding, and cigarette burns and grooves in the kitchen counter. I'll give you this list if you like.
Always show, or permit the bailiff to show, any documents or other physical exhibits to the opposing party before you request that such matter be received by the judge as evidence in your case. It is necessary that you do this so that the opposing party may be able to state a position on the admissibility of such proposed evidence.
Are you asking me to receive this into evidence?
Yes, Your Honor.
If there's no objection, Ms. Tennant, I'll receive this into evidence as Defendant's Exhibit Number 1.
And I took some snapshots, Your Honor. I'd like these into evidence, too.
Bailiff. If there's no objection, Ms. Tennant, I'll receive these photos into evidence as Defendant's Exhibit Number 2.
Just look at that carpet. So I said to Jack, get your men up there and take care of this mess. Jack's good with things like that. He doesn't drink on the job either. So he fixed the damage, and he gave me a bill for time and materials that totaled $1,500. I still owe him $825, so I need that security deposit. Jack will tell you himself what it cost to fix the place up.
Thank you, Mr. Owner. Is that all you have to tell me?
Yes, Judge. That's all there is to tell.
Ms. Tennant, do you have any questions for Mr. Owner?
Yes, Your Honor, I do. How can you keep my money from me? Haven't you heard all of the things I've said?
Judge, do I have to answer that question?
No, you don't, Mr. Owner. Ms. Tennant, you're being argumentative. Please ask questions that relate to Mr. Owner's testimony here today.
I'm sorry, Your Honor. Mr. Owner, you think you kept a pretty nice apartment, didn't you?
Yes. I pride myself on my properties.
And you said earlier that this apartment was perfect when I moved in, didn't you?
Yes, and I stand by that statement.
Well, in fact, this apartment is pretty old, isn't it? About 23 years old?
So what if it is? That's practically brand new in historic Alexandria.
The apartment was in pretty bad shape, in fact, when I moved in, wasn't it?
Not really.
In fact, in the last 23 years, you haven't done anything to improve that property, have you?
Sure I have. Why, in 1969, I put in a new refrigerator. In your unit, as a matter of fact.
What about since that time?
Well, I put some shrubs around the foundation.
Isn't it true, Mr. Owner, that you and Jack came into my apartment on numerous occasions when I wasn't around?
We had to make sure your rodent wasn't tearing up the place.
Isn't it true that you and Jack popped the lock on my door a couple of times?
No, we just opened it, that's all.
You testified that you got Jack to unlock the door for you, correct? Isn't that true that that is how the hole got into the door?
No, we just made a small hole somewhere else.
Well, in fact, you knew a long time ago, before the end of the lease, that I had a pet, didn't you?
I knew something or somebody was tearing the place up.
But you never told me to get rid of my pet, or ever asked if I had pets, did you?
You were never around.
Did you ever leave a message or a note?
I asked your neighbor to have you to call me.
I don't know my next door neighbor, and I'll bet you never left a written notice either, did you?
No.
Now, the fact of the matter is you were never concerned that I had a pet, right?
Sure I was. I never wanted any of my tenants to have pets.
Apparently, and you let me keep my pet ferret Pookie for 2 years.
Remember, when examining witnesses, you are only permitted to ask questions, not to make comments. Miss Tennant's remark about the pets was inappropriate. Comments and statements are only permitted during opening statements and closing arguments.
Ms. Tennant, please restrict yourself to simply asking questions. You'll have your chance for comments during closing argument.
I'm sorry, Your Honor. I have no further questions, I guess.
Thank you, Ms. Tennant. You may step down, Mr. Owner, and we'll hear from your next witness, if you have one.
Your Honor, my next witness is my handyman, Jack Hammer.
Mr. Hammer, if you'll come forward and take the witness stand, please.
Jack, would you tell the judge your name, please?
Yes, my name is Jack Hammer.
And did you work on this apartment for me?
I sure did. When this lady moved out, you told me to go in and do everything that needed to be done to fix the place up. So me and my 2 men went in right away, and we got the place looking better than it did before she moved in, if I do say so myself.
Is this the bill you gave me for the work you did?
Mr. Bailiff, please show that to Ms. Tennant, would you?
Please take a look at that, please.
Yeah, it sure is. I wrote it up myself. It has all the things we did right here on it. First, there was a big hole in one of the doors, and we had to patch that up. And the kitchen countertop, that was a real mess. There was this lime green thing, and we replaced that with a nice marble countertop. And the molding in the kitchen, it looked like it'd been chewed and gnawed on, so we had to replace that. And after I got the molding in the kitchen up, it didn't go with the rest of the house, so I did the rest of the apartment the same way. And we took out the old carpet and installed brand new carpet. And for all that work we did, I don't think I overcharged you with this bill for $1,500.
Do you wish to introduce this bill into evidence, sir?
Yes, Your Honor.
Is there any objection, Ms. Tennant?
No, Your Honor.
Be received into evidence as Defendant's Exhibit Number 3.
I have no more questions of this witness, Your Honor.
Thank you. Ms. Tennant, you may cross-examine if you wish.
Mr. Hammer, you stated that you fixed up the place and got it much better looking than when I moved in. Would you explain the condition of the apartment when I moved in?
Well, it wasn't beautiful, but it was livable. It looks a lot better now with a new marble countertop.
Were there scratches and burns on the countertop when I moved in?
Really don't know, but there were plenty of scratches and burns on the countertop that I replaced.
What condition was the carpeting when I moved in?
Well, there was some stains on it, but not nearly as bad as when I replaced it. It got really bad on account of your animals using it for a latrine.
How did you happen to know that I had a pet in the apartment?
Well, yeah, I went in a couple of times with Mr. Owner, and yeah, I thought that was all right at the time, Judge, but I guess from what I've heard today, it really wasn't.
Mr. Hammer's last remark was potentially damaging to Mr. Owner's case and was totally unnecessary. Mr. Hammer was not asked if he was allowed to be in Miss Tennant's apartment. It is important that your witnesses understand that they must tell the truth. However, you should counsel each of your witnesses to answer only the questions asked, and not to volunteer other information or opinions which do not directly respond to the questions themselves.
When we went in the apartment, what I saw is this, what do you call them, a ferret, just running all over the place and chewing on the molding and using the floor and the rug for a bathroom. Place looks a lot better now that I put that new countertop in and did those other improvements.
It sounds as though you worked hard on the fix-up, Mr. Hammer, and that you enjoyed your work. Is it possible that you did extra projects in the apartment?
Well, I did enjoy my work, and I think it turned out real well. But to answer your question, as I said before, Judge, when I put the new molding in the kitchen, it looked so good that I decided to do the rest of the apartment the same way.
Is there anything else you'd like to ask the witness?
No, Your Honor, that's all I have.
All right, sir. Any questions on redirect, sir?
No, Your Honor, I have no further witnesses.
Ms. Tennant, do you wish to make a closing argument?
Closing argument permits you to review the evidence in the case and to state to the judge the reasons why the evidence supports your case. It is not a time to offer new evidence, and what you say during closing argument is not considered evidence.
Even if the bedroom door was damaged, a little bit of plastic wood could have solved the problem instead of replacement of the entire door. Mr. Owner should not be allowed to remodel the place at my expense. Also, the carpet was definitely not new when I moved in. Like I said before, my ferrets had a little trouble with potty training, but I always cleaned up after them and sprinkled carpet fresh over the affected area. I'm a very clean person, really. Besides, even if there were stains, they are no worse than the other stains that were on the carpet when I moved in. Also, the kitchen countertop was a hideous lime green color, obviously a holdover from the 60s, and that was due for replacement soon anyway. Any nicks or dents in it should be considered normal wear and tear. And I cannot be held responsible for chewed up molding in the kitchen. It was like that when I moved in, and I should not be responsible for paying for its replacement. In conclusion, I maintain that Mr. Owner is trying to redecorate the apartment at my expense. He should be stopped from doing so, as it is illegal in Virginia. My coworker Marge went through this same type of situation with her landlord, where he tried to keep her security deposit for bogus claims of damage to the apartment. The judge said that the landlord was stopped from keeping the security deposit. Mr. Owner probably keeps everyone's security deposit as a matter of course and doesn't think anybody will go against him to challenge him in court. Well, he's wrong.
Miss Tennant has strayed from the evidence presented in the case. She should not have discussed her co-worker's experience or have speculated on Mr. Owner's treatment of other tenants. Do not damage or dilute the strength of your case or harm your credibility with the judge by discussing matters which were not addressed as evidence.
In addition for my neatness and cleanliness, I have always been known for my guts. Any damage to the unit should be deemed either as normal wear and tear or ought to be assessed on the basis of the depreciated value of the items replaced and the reasonable value of labor associated with such repair or replacement work. Thank you for your attention.
Thank you, Ms. Tennant. Mr. Owner, do you wish to make a closing statement?
The evidence clearly shows that Miss Tennant made a dump out of a nice apartment. She threw away the beer cans, but she left the place worse off than when she found it. I have the right to hire my man to fix the place up, and I can't help it if everything costs more these days. You can't hardly buy depreciated carpet or countertops, and those things could have gone on fine for years if she hadn't ruined them. I should be allowed to keep her security deposit to pay for what it cost me to fix her damages. Thank you.
Yes, sir. Thank you. Is there anything else, Ms. Tennant?
No, Your Honor.
The plaintiff always has the final opportunity to address the court in closing argument. However, in addressing the court a second time in closing argument, the plaintiff should restrict her statements, if any, to a rebuttal of the points made by the defendant in his closing argument.
Ms. Tennant, I'm satisfied from the evidence that you are responsible for some of the damages that had to be repaired to the apartment. I do, however, agree with you that Mr. Owner is not permitted to refurbish the apartment at your expense alone. I find the repair charges on this bill to be fair and reasonable as related to the damage to the door. Also find that the labor charge for replacement of the carpeting, molding, countertop are fair and reasonable. It is clear to me, Ms. Tennant, that you have hastened the day on which these items would have to be replaced. However, Mr. Owner cannot be permitted the benefits for many years to come of a newly decorated unit, refurbished totally at your expense. Moreover, I will not assess against you the cost of the use of the mahogany molding and marble because it would be unfair and unreasonable. There's no evidence before me of the approximate depreciated value of the items replaced. Ms. Tennant, of your $675 security deposit, I find your former landlord should be permitted to retain the sum of $475. Therefore, you're entitled to a judgment. I'll enter a judgment for you, amount of $200, with interest and cost from today. Now, if either of you wish to appeal the judgment of this court, you must note your appeal within 10 days of this date. You must perfect your appeal within 30 days of this date. The appeal bond for the plaintiff would be $50, and the appeal bond for the defendant would be $250. This appeal must be perfected by the posting of the bond and the payment of what's known as a writ tax within 30 days of the date of this judgment. If you do appeal, your case will be heard anew. Start from the beginning in the circuit court before a new judge, a new court, a new case on a new date. Any questions you have about your appeal, the clerk should be able to answer for you. Thank you. That completes the docket. Court stands adjourned.
All rise. Court now stands in recess.
You have just seen a trial in General District Court, and you know how it ended. Now we'll show you what Teresa Tennant had to do to start her case. To commence a lawsuit in General District Court, the form that is most often used is called a warrant in debt. This is the complaint and civil summons that an individual may use to begin the process of collecting money damages of up to $10,000. The form may be obtained from the clerk of the General District Court. As you will see, it is very easy to fill out. For the trial you just saw, the warrant in debt looked like this. Note that on the right side of the form, space is set out for the parties' names and addresses. The person filing the claim is known as the plaintiff, and the party being sued is called the defendant. The plaintiff fills this section out when he or she files the suit. First, in the top portion, the plaintiff types or writes legibly his or her own name and address. Then the plaintiff fills in the bottom portion with the name and address of the defendant. It is very important that the correct name and address be used, because errors in this section can cause two problems. First, without the proper name and address, the sheriff might not be able to serve the defendant. Second, with these errors, any judgment obtained might not be valid. If the defendant is an individual, there is usually not a problem. The plaintiff simply uses the defendant's real name and current address. If the plaintiff is suing a business, however, it may not be as easy. Each business has an official name, and the plaintiff must sue the business by using its official name. If the name a business uses to transact business is a fictitious or trade name, then the plaintiff must determine the defendant's official name. For instance, if a plaintiff wanted to sue a service station for performing faulty repairs, he or she may not simply sue Joe's Garage. The plaintiff would have to find out the official name of the business, which might be Joe's Service Station and Auto Repair, Incorporated. A plaintiff must also include the name of a specific person authorized by law to accept the warrant in debt. That person is called the registered agent if the business is incorporated. This means that if Bob Jackson was the mechanic who did the faulty repair work, and Al Jones was the manager of Joe's Garage, the plaintiff would not name either man in the lawsuit unless one of them is the registered agent or an officer of the corporation, otherwise authorized by law to receive process. Often, the registered agent is the attorney for the business or one of its corporate officers. The address of the registered agent is the address you would include in the bottom portion of the right-hand side of the warrant in debt. If you need to learn the official name of a business or the name of its registered agent, you may get that information by calling Virginia's State Corporation Commission. Once again, it is important to use the official name and address of its registered agent, or else you might not be able to get a valid judgment. The middle portion of the warrant in debt is labeled Claim. This is where the plaintiff tells the court and the defendant why the lawsuit is being filed. The plaintiff identifies the amount of money he or she believes is owed and the beginning date for an award of interest. In the blank for interest rate, the plaintiff should put the word legal, unless the plaintiff had an agreement with the defendant as to the interest rate. If such an agreement exists, the plaintiff should put the agreed to rate in the blank. The judge will determine the date upon which any interest claimed could begin running. Unless an earlier date is identified in the claim section of the warrant in debt, interest will begin running from the date of judgment. That date is usually the trial date. In the blank for costs, the plaintiff should put the amount it cost him or her to file the warrant in debt. Then, in the blank for attorney's fees, an unrepresented party should normally insert the numeral 0, or leave it blank altogether. As with interest, if attorney's fees are claimed, the judge will determine if the defendant will have to pay the plaintiff's attorney's fees in addition to court costs. Keep in mind that a judge can only award fees that the plaintiff requests. If the plaintiff expects to be represented by an attorney by the time the case is heard in court, he or she may wish to preserve rights to the possible award of attorney's fees by placing the word reasonable in the blank for attorney's fees. Not every claim, however, permits the recovery of attorney's fees, even if the plaintiff is represented by an attorney. Finally, there is a space for the plaintiff to explain briefly why he or she is entitled to the money identified in the warrant in debt. The blanks in this section cover the most frequently filed types of claims in General District Court. The plaintiff should make it clear in this section why the money is owed. If it is inappropriate to check one of the first 3 boxes in this section, the plaintiff should check the box marked Other and briefly explain why the defendant owes the money. In most Virginia jurisdictions, either the clerk or the judge will fill out the case disposition section at the time of or shortly following the completion of the case. It would be a good idea to verify from the clerk of the court in which the warrant in debt is to be filed that the plaintiff is not expected to complete any portion of this section. There are other documents that the parties may be asked to file in connection with claims to be heard in the General District Court. One of them is called a Bill of Particulars. A Bill of Particulars for the case you just saw would look like this. A defendant who is served with a warrant in debt and wants the plaintiff to identify his or her claim in greater detail can ask the judge to order the plaintiff to file a Bill of Particulars. This is a writing by the plaintiff setting forth facts and circumstances of the claim more precisely than in the warrant in debt. Another document frequently filed in cases before the General District Court is the Answer and Grounds of Defense. An example of an answer and grounds of defense for the case you just saw would look like this. This is a writing by the defendant setting forth any factual and legal reasons why the plaintiff should not be awarded judgment on the claim. A plaintiff can request that the court set a date by which the defendant must file an answer and grounds of defense. Once a judgment for a sum of money is awarded by the court, the parties are sometimes referred to thereafter not as plaintiff and defendant, but rather as judgment creditor and judgment debtor. Many people believe that a case is over when a judge says at the end of a trial that one party owes money to the other. This is often not the case. Frequently, the judgment debtor either refuses to pay or is unable to pay in full the money that is owed. If you, as the judgment creditor, find yourself in such a position, you may have no alternative but to enforce your judgment through garnishment or through a sale of the other party's property. If you do not know the nature and location of the judgment debtor's assets, including his or her place of employment, you may wish to have the court issue a summons to answer debtor's interrogatories. A summons to answer interrogatories form looks like this. By using this procedure, you can compel the judgment debtor to come to court to disclose such information under oath. Once a judgment creditor determines the judgment debtor's place of employment and the nature and location of his other assets, the process of levying and/or garnishing can begin. You may find that a judgment obtained against an employed individual can be satisfied over time by means of a garnishment of the judgment debtor's wages or salary. A garnishment of this nature requires the judgment debtor's employer to withhold a certain percentage of its employee's wages or salary for limited periods of time during which the judgment remains unsatisfied. Even without the aid of an attorney, you may be able to initiate a garnishment action against the judgment debtor's employer. For other enforcement procedures, however, such as a sale of the judgment debtor's assets, you are advised to consult an attorney. These methods are effective, but tend to be complex. Please keep in mind that the purpose of post-judgment procedures is to obtain satisfaction of the judgment awarded at the conclusion of trial. It is important that you realize that the General District Court will process papers and forms that you present to its clerk's office, if they are properly filled out, to aid you in collecting the money to which you are entitled as a judgment creditor. However, it is you who must initiate and follow through with the post-judgment procedures that are available. We hope you have enjoyed and will benefit from our presentation. Remember, every case is different, and if you have any questions about your own case, we recommend that you see an attorney. Your local Bar Association's Lawyer Referral Service can be relied upon to help you.